those are change of circumstances which the court can take into consideration in terms of what should happen by way of the continuation of maintenance orders.
Those like yourself who do this daily will understand quickly what you mean, that your conditions have improved. I think for our listeners to be very clear on what you just said there is there can be relief given to one by the court.
Yes.
But as you right now, you let's say at a scale of $50,000, but by next month, this is the maintenance we're talking about. By next month or the next 6 months, you get an increase up to $70,000.
Yes.
It means that the person who received the relief can now go back to the court and say, listen, his circumstances have changed.
His circumstances has
more.
changed, but not just because his circumstances has changed. His circumstances has changed, but your situation also. There must be something by way that has affected your situation such that you can make that application.
Which is not very
In
hard,
other
the
words,
cost of living.
The cost of living, exactly. That is a factor. But it might be as well that you might have found yourself in a situation. For example, you might find that your partner to whom you were paying maintenance has won the lottery. And that might mean that their financial position is in fact has been enhanced, and therefore there is no longer the need for financial provision to be made. They may have remarried. So that if it is that that person has gone on, formed a new relationship, has gotten into a marriage, then you can, that is in fact basis for the court making, reviewing the situation as to whether or not it is fair that maintenance should continue to be paid.
But just to be very clear, because I think that very low level makes it very clear, from 50,000 to 70 or 75,000, whatever, you have increased your income. The other parties say the cost of living has gone way up high. My kids says this has gone. No. They can go to the court and say, I want a higher percentage for what he has, where his income is appreciated. I mean, is that in essence what we're saying?
Theoretically, it is possible. But what I want to say is that the court is not cavalier about making those orders.
I don't think they are.
So that the fact that one has an increase in income by itself would not entitle you to an increase in maintenance. So that the court looks at the circumstances as a whole. So it's not like because I have an increase in income, it means that i.e. and then therefore you're entitled to maintenance, to an increase in the maintenance.
Thank you for joining us inside Brunch this morning. My guest is attorney Hyacinth Griffith. She is in the area of adoption, child custody, parental child abduction, child protection, and marriage. It is the Cohabitational Relationship Act of 1998 is what we are discussing this morning. There's an aspect of this alternative route in the provision speaks where there must, in order to benefit from property, for instance, you must show that there was an intention that they would have a beneficial share of the property through express words. I know there are ways to do that, i.e. if you went in for a mortgage and you named the person's income and so on, all that contributed to the property. But if the party is making a claim on property, I see there's a part of it here that says, as I intimated just now, that the claimant must show that there was an intention from the defendant, as it were, that they would have a beneficial share of property through express words. I'm a little lost on that area.
I think, let's put it this way. When you are involved in a cohabitational relationship, there is, and it is, as the court requires, on a bona fide domestic basis. It means that there is a commitment in that relationship to share. And because there is a wide discretion that the court has in terms of direct and indirect contribution, the question of how you prove that intention, that this is something that we are sharing in, is the court has a wide discretion as to how the court regards the assets that are acquired during the period of that cohabitation. So that if it is that this is something which was acquired during the period that we are cohabiting, even if it is that I did not make a direct contribution to it, it might be, and I can't provide a document where you undertook to give me some share of it. The court can hear the evidence as to how your relationship worked and what might have how you have conducted yourself during that relationship to form a view as to whether that there was that intention. Because a cohabitational relationship is now legally recognized. You see, before the act, it was the cohabitants, because they were not called that at that time, the common law relationship, the persons who were living together, they had to establish, and it was in the nature more of a trust principle, so that it was that you had to provide your receipts. And in fact, that was the unfortunate situation that obtained before. You had to actually show that you went to you paid, you spent this exact amount of money, you have the bills and the receipts. If you can conceive of that situation over a relationship, who really is keeping the bills? You are in this. But despite that, because of the fact that the relationship had not been recognized in the way that it is now recognized under the Act, the court could not have looked at anything but the actual evidence, tangible evidence of contribution. What the Act has done is that it gives the court a wide discretion to look at the relationship of the parties and to infer that intention based upon how you have conducted your affairs. And for example, there is in fact a case which has gone to the before the courts here, where one of the cohabitants, the parties, was in fact residing in the United States, and her partner was in fact in Trinidad. However, she would send things, we are industrious in the Caribbean. We go off, we work for 6 months. We try to make some money. We purchase things and we send them in a barrel. And she had been in the habit of doing this. And at the end of the relationship, the question was whether or not there had been a cohabitational relationship, because she had spent so much of that time outside of Trinidad and Tobago working. But the evidence supported the fact that there was a bona fide domestic relationship. They communicated. In her resources, she sent back to Trinidad to invest in the home. She had no legal interest that was identifiable in terms of by way of the deed, even the things which she had purchased, which she had sent, because the husband was on the ground here in Trinidad. So that the court looks at the relationship, and the court has to be mature to understand our Trinidad experience and the context of how we live and operate here. And the fact is that there are many persons in Trinidad, for one reason or another, who have been married, but they do not have a divorce, but they form a serious relationship, and one where there is a level of commitment to that relationship. And it does not equate a marriage, but it is a relationship that the court recognizes.
31 minutes after 11 o'clock, you're inside Brunch. My guest, Hyacinth Griffith, and we're talking about the 1998 Cohabitation Relationships Act. I knew that word would get me in trouble at some point.
One of the things that I wanted to say is that we speak about things that most people think of immediately in terms of maintenance. We think of a house and so on. I think a very important step which was taken in terms of dealing with this Cohabitation Relationship Act is when the relationship was recognized in the Succession Act, so that a cohabitant has been specifically recognized as entitled to share in the estate of the deceased. And of course, previously our Succession Act had no provision for that. Now we also have the recognition of cohabitants in our Workmen Compensation Act. It is also recognized in our National Insurance Act. The cohabitant is recognized as entitled to relief under the Domestic Violence Act. And so it is more and more you find that relationship has in fact been recognized as a legitimate relationship. I'm not speaking now about what, in terms of a faith position. I'm speaking about legitimate from a legal perspective, has been recognized as a legitimate relationship, recognized at law, which entitles the participants in that relationship to an interest and for benefit.
Which is precisely why we took this at such a premium, because domestic violence is real. Economic security is one of the reasons advanced why many people stay in relationships. What is going to happen to me if I left him?
Yes.
And we just wanted to make it clear to many victims and to the populace at large, there is relief for common law relationships.
Yes.
As long as people understand that, then you are no longer chained in this thing of what happens to me should I leave him. It is that sort of direction we wanted to make clear, because I do not believe, even from the conversation this morning, and my excuse of having just come back is not anymore an excuse. I think I've been here for a year, so that's enough. But there is a lot of ignorance going on as to this law, this piece of legislation, this act, that it is in fact there. Men don't understand it. Women don't understand it. This is not to say that abuse is one gender or the other.
Yes.
But there is just a general, just general ignorance as to this act and what in fact it does. It does, from my extrapolation, and you will correct me if I am wrong, just in degree reduce some of the benefits, but really just in degree. At the end of the day, it is almost the same like a marriage. Almost the same.
It's, I guess,
qualifier.
I'm reluctant to say almost, because then I will have to explain what the almost is. But I do understand that, and I think what we need to understand is that a cohabitational relationship is a serious relationship, and it carries legal consequences. And I think that is something that all of us in Trinidad need to be mindful of, because sometimes we believe that we can just move from a relationship one into the other without understanding that, because in the view that, I didn't marry her, that does not cut it.
Not anymore.
And not anymore. And the other thing that I want to say is that the idea, in terms of the reason that I think that it has become so, it became so pressing that they did in fact recognize this, is because before the act was introduced, there was a lot of, it really worked an injustice to parties who were engaged in that relationship, committed to that relationship, invested of their time, their effort, their finances. But because they did not have the legal status of a marriage, they really had to move away from that relationship at the end of it with nothing. And I think that was really unfair to the persons. Quite often you found that it was the male might have purchased the house in their name, the other party might have been a homemaker, looking after the children, taking care of her partner, and at the end of the day, because the relationship had not been recognized, even if it had spanned 20, 30 years, there was nothing other than maintenance for the children.
It is a very serious step when you take it, just as serious as if you, legally, as if you went before a priest to do it. It is not something you can cavalierly walk into, dispatch of, and think you can move on. No, it can pull you back to heel, as we would in training.
The other thing that I wanted to say is that persons sometimes do not realize that there is a limitation period for bringing that claim. So that, for example, if you are married and your husband has gone off, there's no limitation when you can bring a claim for financial relief.
Interesting
distinction. You are married, but you are legally married, but you are actually separated. But that does not mean that your entitlement evaporates after the passage of a particular period of time. In the with a cohabitational relationship, however, you must bring your claim for relief within 2 years of the end of that relationship.
Just to be very clear, because in the case of a marriage, with the registry, the marriage certificate is the witness that you were married. In the case of a common law, it is a different level.
It is what we say.
Yes.
But even if you establish that you did have a cohabitational relationship,
you have to do it.
You must seek your financial relief within a prescribed period, which is 2 years. This is not about maintenance for children. Maintenance for children comes under the family law guardianship of minors, and that does not expire with time. So that I'm not speaking about the children of that relationship who will always be entitled after you have established whatever needs to be established,
Mhm.
paternity perhaps, the fact that the